I was watching Patton, looking at minutes 21 to 23 of this DVD. It looks like Patton, in the character, Patton was promoted by the president subsequent to approval by the Congress. Patton has his aides go ahead and award him his third star, I think, before the receiving communication from the Congress that it was approved. I'm a little interested in the actual date of the filming of that incident, in light of MacArthur, Gregory Peck, and Douglas MacArthur, kind of concerned about whether or not there's a military intelligence group for each, general, for instance. And then maybe George Fisher evidence. This is the 2008 George Fisher. You got the co-conspirator statements as part of hearsay, exceptions to the hearsay rule. And it might be a mildly interesting hearsay, video say, thought to worry about that Patton admission. So co-conspirators, like for instance, prior statements by the witnesses, you have prior inconsistent statements, prior consistent statements. There are rules for each of these when it comes to exceptions to the hearsay rule, what can be admitted. It gets so confusing and complicated. You have several generations of attorneys who don't exactly know how to pass on full reemphasis of entire learning. Eventually your court system may lose thorough understanding of the law of hearsay, and which might affect the law of surveillance say. A note on, even though I don't think surveillance say is even mentioned by anyone but me, I don't know how else you understand video other than through the hearsay rule and the foundations, psychological foundations for hearsay, why we might accept it, why we might not. Let's look at a note on the next case, Bourjaily versus the United States, 1987. Looks like there's some kind of entrapment going on here that is probably legal, according to the handbook, FBI handbook or something. I don't know why it's legal. I'd be interested to find out. But a note on the next case, these preconditions are, what is it? Those disputes all concern the co-conspirator exception to the hearsay rule, and specifically how to decide if the preconditions of that exception had been met. Those preconditions are, I think he's got 3 bullet points, that a conspiracy existed at the time of the out-of-court statement was made. It's hard to grasp what I'm trying to say until you read this some. We've got an informant working for the FBI arranged to sell 1 kilogram of cocaine to Angelo Leonardo. I'm not sure what kind of judicial agreement they've got, but Leonardo agreed that he would find individuals to distribute the drug. He's already an informant. I assume he has some kind of agreement with the FBI. When the sale became imminent, Leonardo stated in a tape-recorded telephone conversation, well, I mean, there's definitely wording, verbal agreement, if nothing else, based on informant, implicit agreement built by multiple conversations, or does he have a contract as an informant? That he had a gentleman friend who had some questions to ask about the cocaine. In a subsequent telephone call, Greathouse spoke to the friend about the quality of the drug and the price. Greathouse then spoke again with Leonardo, and the two arranged the details of the purchase. They agreed that the sale would take place in a designated hotel parking lot, and Leonardo would transfer the drug from Greathouse's car to the friend, who would be waiting in the parking lot in his own car. Greathouse proceeded with the transaction as planned, and FBI agents arrested Leonardo and Petitioner immediately after Leonardo placed 1 kilogram of cocaine into Petitioner's car in the hotel parking lot. In petitioner's car, the agents found over $20,000 in cash. It's a big case. Several pages going on. Co-conspirator. Do conspiracies exist? No.